Eagles, you have the right to listen to this lecture. Anything I say can and will be used against you on the AP exam. You have the right to listen to your eagle. If you choose not to listen to your eagle, you will be led down a dark path of despair. Do you understand these rights that I have read to you? Good. Now let's get started. Today's presentation is going to cover the differences between civil liberties and civil rights. We're going to start with civil liberties. Now, when I say civil liberties, I mean, what does that even mean? What does it mean to say civil liberties? Okay, let's put it very simply, as simple as I can. Civil liberties is all the stuff in the Bill of Rights. It should be called the Bill of Liberties. It'd be less confusing, but it's not. It's called the Bill of Rights. Nonetheless, all of the stuff in the Bill of Rights, your freedom of speech, your freedom of the press, those are civil liberties. Okay, so when I talk about applying civil liberties or protecting civil liberties, how does that even work? The liberties listed in the Bill of Rights are going to protect you from government actions. Now, when we think about this, we have to go back to the original debate in the Constitutional Convention. Remember, the Anti-Federalists really feared a tyrannical central government. What can stop a president from becoming like King George, right? So the Anti-Federalists demanded, hey, if we're going to agree to this new Constitution, we got to have a way to have our basic liberties protected. And therefore, we must add a Bill of Rights to the Constitution to protect ourselves from a tyrannical government. Now, Eagles, this semester, I've asked you to know your Supreme Court cases, your foundational documents, but I've also asked you to know your amendments. And I want you to have an emphasis on the Bill of Rights. The Bill of Rights is the first 10 amendments to the Constitution. They were added first. The articles were ratified, and then in the first session of the first Congress, the Bill of Rights were added. You should know these first 10 amendments. They are going to, basically today's presentation is going to go through these Bill of Rights and talk about the civil liberties within them. Now, at the start, I kind of debated where to talk about selective incorporation in this presentation. And I'm like, oh, do it last, man. But you know what? I'm going to do it first because this is the most complicated issue in today's presentation. So feel free to, watch this over again or this part. But you need to understand what the term selective incorporation is. Okay. When I talk about selective incorporation, the question I have is, did states always follow the Bill of Rights? No, they didn't. Not at first, at least. When the Constitution was ratified and the Bill of Rights were added, states didn't necessarily have to follow the Bill of Rights. Do they follow the Bill of Rights now? Yep, they sure do. Okay, so at the start, they didn't, but now they do. So what happened? Selective incorporation happened. Okay, so the Bill of Rights now is followed by the states. What is selective incorporation? Okay, so the question is, what is selective incorporation? All right, so if the Bill of Rights now applied to the states, how did that happen? Well, the Bill of Rights includes a lot of different liberties, everything from freedom of speech to right to bear arms, the right to an attorney. All those liberties, they were individually applied to the states in a specific case. So it didn't happen all at once. You had to have a case for this liberty and then a case for that liberty, right? Okay, so when did this process start of incorporating the liberties listed in the Bill of Rights to apply to the states and the federal government? It happened in the 1920s, right? These liberties listed in the Bill of Rights were incorporated to the states through each one through a different Supreme Court case. And it didn't happen all at once. Each liberty listed in the Bill of Rights was addressed, in a select Supreme Court case. And that is why it's called selective incorporation. It happened over time in a select group of cases. So I think the best way to describe selective incorporation is to give you an actual example of how it worked. So see the dude there in the corner, the old guy there with the glasses? That's Clarence Earl Gideon. Okay, and he's obviously going to be the dude in the Supreme Court case Gideon versus Wainwright. Now, this particular liberty that we're going to incorporate to the states in our example here is the Sixth Amendment right to counsel, or the right to an attorney. Certainly you've heard about this before. Everybody has the right to an attorney. If they can't afford an attorney, one will be provided for them, right? Okay, that's in your Miranda rights. You have the right to remain silent, you know, that whole thing. If you can't afford an attorney, one will be provided for you. Okay, Sixth Amendment right to counsel. What happened? In the Gideon Wainwright case, right, this will be incorporated. Prior to the Gideon case, states were not required to provide an attorney to a defendant who couldn't afford one. So if you were poor and you couldn't afford a lawyer, too bad. Dude, I'm way too poor. What the heck? And that happened to Clarence Earl Gideon. He was arrested for petty theft. They say he robbed a pool hall. He stole some drinks and some change. And when he had his trial, he didn't have enough money to, hire a lawyer to defend him. And he wasn't exactly the sharpest knife in the drawer, right? So when he asks the judge, hey, I can't afford a lawyer and you're supposed to provide one for me, the judge says, sucks for you, dude. No, I'm not. You don't get an attorney. And the guy's convicted, before dinner, right? He's thrown right into the slammer. So Gideon will actually appeal his case to the Supreme Court and say, hey, I was wrongfully convicted here because I was denied the right to an attorney. So Gideon does get his case to the highest court in the land. And in the Supreme Court case, Gideon versus Wainwright, it was ruled that a lawyer must be provided for everybody, the rich and the poor, by both the states and the federal government. Okay, now why? Why did they make this ruling? And this is key. This is where selective incorporation really takes hold. Because the Sixth Amendment says that everybody deserves the assistance of counsel. And the 14th Amendment says no state shall deprive life, liberty, or property without due process. Okay, so there it is. The 14th Amendment, no state shall deprive assistance of counsel. So through the 14th Amendment, the Sixth Amendment applies to the states. Oh yeah, baby. Okay, so the 14th Amendment. This is the key to selective incorporation. It's going to act as the glue between the Bill of Rights and the states. Let me read it to you guys again. No state shall deprive any person of life, liberty, or property without, and here it is, due process of law, nor deny any person within its jurisdiction the equal protection of the laws. So if a state were to say, hey, you know what? We don't need to follow these liberties in the Bill of Rights, the counter argument to that is actually you do. And the reason why is the 14th Amendment says that no state shall deprive due process. And over time, each one of the liberties in the Bill of Rights was incorporated to apply to the states. Now, the due process, so the 14th Amendment creates this, but specifically, it's the due process clause within the 14th Amendment. Okay, so just to simplify it and wrap this up, the Bill of Rights, the states, 14th Amendment. Okay, because of the 14th Amendment, the Bill of Rights now applies to the states, and it happened through a select group of cases, and that is why it's called selective incorporation. Okay, so now that we've identified what selective incorporation is, let's go ahead and start listing these liberties that I'm talking about. So what I want to do with the rest of the presentation is go through the different liberties listed in the Bill of Rights, talk about how they're applied, how they're incorporated, and what they do. Obviously, we're going to start with the First Amendment. the First Amendment itself can be considered, several amendments combined into one. It's just humongous. I mean, you can't say one amendment's more important than the other. They're all important, but you can make a pretty good case for the First Amendment. Okay. The First Amendment includes freedom of religion, freedom of speech, freedom of the press, the right to assemble, and the right to petition the government for a redress of grievances. So, First Amendment's huge. All right, let's start at the top with freedom of religion. Everybody in the United States, or most people, know we have freedom of religion. But what most people don't know is that it actually has two parts to it. It's a double-edged sword here. Freedom of religion is there's two parts. There's two clauses, as they say. Two clauses that establish freedom of religion. The Establishment Clause and the Free Exercise Clause. Basically, the First Amendment reads, Congress shall make no law respecting an establishment of religion or prohibiting the free exercise thereof. So your basic civics class will, make sure you understand the First Amendment has freedom of religion. But in this class, Eagles, you need to be able to differentiate between the Establishment Clause and the Free Exercise Clause with regard to freedom of religion. Now you see the little students there in that picture. They're praying and they're in class at the same time. So I think you know where I'm going with this. We'll talk Establishment Clause first. Okay, First Amendment Establishment Clause. You can see down here that you have this political cartoon that has a fence here that's saying separation, and you got church and state, right? This is obviously referring to the wall of separation, and that there's this, separation between church and state. And then again, up here in the corner, you have some students that are praying, and they're being led by their teacher. And that's you just can't do it. There's a separation between church and state as the Establishment Clause dictates. Okay, so what is more specifically an example? Oh, well, the Establishment Clause, there shall be no national church, right? This creates a wall of separation, or in other words, a separation between church and state. The founders or the framers of the Constitution were nervous about the government telling the people how they should worship and, giving favor to one specific religion over another. So they established that there will be no established church, the Establishment Clause, right? Okay, now the case that you need to be aware of, hopefully you already knew this, was Engel Vital. In Engel Vital, you have a school in New York, and they're starting the morning off with the morning prayer. And it was technically non-compulsory, right, or you didn't have to do it, but let's be honest, if you're required to be at school and everybody goes to school and then there's a prayer going on, you are essentially having a government entity force you to be involved with a prayer. And some people are, not okay with that. So the question is, can a prayer be read to start class in a public school? Nope, that can't happen. It happened in the past, but not after this Supreme Court case. In Engel Vital, SCOTUS, meaning the Supreme Court of the United States, ruled that this reciting of the prayer was a violation of the Establishment Clause and breached the concept of separation between church and state. So you cannot force students to pray. Now, if students want to voluntarily pray, they can, and that's part of the other side of it, the Free Exercise Clause, right? Okay, so we can't, or the government, I say we, I'm a school teacher, so if I were to start class with a prayer, I would be breaking, the Establishment Clause, right? So Establishment Clause, it can't be forced upon you, but it can't be prevented either. That's your Free Exercise Clause. Okay, so we'll go right into Free Exercise Clause. In the First Amendment, you can believe in whatever religion you want. The government will not prevent you from worshiping, the way you want. And the case that they attach the Free Exercise Clause to is Wisconsin Yoder. In this case, you had an Amish community, that didn't want to send their kids to school after a certain age. But the state of Wisconsin had a law that said, yeah, kids need to go to school past the 8th grade. And if you didn't send them, you would be fined, right? So this Amish community is like, dude, no, you can't force us. That is against our religion. That is against the free exercise clause. It's, so nope, a state cannot make kids go to school past the 8th grade. The Amish parents said, hey, we don't want to send our kids there. This Wisconsin law violates the free exercise clause. Okay, so to recap, the government will not establish a national church. And at the same time, they will not prevent you from worshiping the way you want to. At Skyline High School, we have the seminary building, right? That's just across the street, or it's theoretically right there, like it's in the parking lot. So the school can't force you to go to seminary, but can't stop you, right? So that's the establishment clause and the free exercise clause working in tandem there. Okay, moving on. Now, big one in the United States, and this is really big for our country, our culture, is the right for free speech. And I don't need to go over the fact that we have free speech. We all know we have free speech. What I need to make sure you guys understand is that free speech is not absolute in the United States. It can be limited. So everybody, I hear it all the time. I have my free speech. I can say what I want, do what I want. I have my free speech. Yes, you do have your free speech. The First Amendment protects it. There's all sorts of examples. We can talk about political speech, right? The Citizens United case. There's examples of free speech all over. However, what are the limits to free speech? That's the details I want you guys to know. Is free speech always allowed? Well, wait a minute. What if someone's speech violates someone else's peace or safety? Eagle's speech is not absolute. Let's go through some limits, right? So in what cases can the government restrict free speech? All right, time, place, and manner. When speech is restricted, the government must have a darn good reason. The time, the place, or the manner of the speech is taken into account, right? So what does that mean in a little bit more detail? Well, what if the speech is disturbing the peace? Or what if it's on private property? Or what if it is threatening public safety? Okay, so these are examples where the time or the place or the manner of the speech is violating somebody else's peace or safety, and thus can be limited. All right, now, what if the speech is intended to damage a person's reputation? So slander is what I'm referring to. What if the speech is offensive or includes obscene statements and gestures? Then yes, the speech may be limited. Defamatory, offensive, or obscene, right? Okay, so time, place, and manner. If the time of the speech, or if it's on public property, or if the manner of the speech is inciting violence, it can be limited. If you're slandering somebody, if your speech is an intent to hurt somebody's reputation, it can be limited. If your speech is offensive or obscene, including gestures, then yes, it can be limited. This also includes printed speech. Okay, this is referred to as libel, and this is where it's like slander but in print form, right? Your speech can be limited if it's intended to damage a person's reputation, although that is very hard to prove. It is hard to get a libel case to prove it. It has to be clear intent to damage somebody's reputation. Okay, so time, place, manner restrictions, and defamatory, offensive, and obscene restrictions on speech. I think I need to go a little bit more on this and give you specific examples. Okay, now, what is an example of limiting free speech? Obviously, Schenck versus United States in 1919 is the best example, and this is also the example where the clear and present danger, clause is established. Okay, so what happened? Charles Schenck. This dude was convicted for publicly opposing the World War I draft, right? I pledge allegiance and silence about the war. Okay, so it's kind of a knock on this whole idea of the Espionage Act. Now, this isn't United States history class, so I won't go into the details of the Espionage Act. But basically, Congress passed a law saying that if you're talking, about the war effort negatively, your speech can be limited. No way, right? No way that's going to be allowed. That goes against the First Amendment. But hold on. This dude, Charles Schenck, was publicly opposing the World War I draft. So even though you would think, yeah, he can do that with his free speech, not so fast. His conviction, Eagles, was upheld. Okay, so his conviction was upheld. The Supreme Court says, sorry, dude, you can't do that because your speech, we're in the middle of a war and we got to win this war. And as a result of you opposing the draft, you're creating a clear and present danger toward our country. And then the example, and it's a great example that you hear referenced often. The court said, for an example, you can't yell fire in a crowded theater. Right? Because if you yell fire in a crowded theater and there's no fire, then people are going to scramble out the door and they're going to trip and hurt themselves. And you just caused harm to somebody because of your speech. So if your speech incites violence or harm, it may be limited. So in the case of Schenck, the court ruled, yeah, dude, because you're opposing the draft, you're creating a clear and present danger. So therefore, your speech can be limited. So when you talk about limits of free speech, the clear and present danger test in the Schenck case is the best example that I could give you. Now, hand in hand with freedom of speech is freedom of the press. Eagles, you literally, without even knowing this, it just is part of the day-to-day routine. Freedom of the press happens all around you every single day. And I think we take it for granted a little bit because in other nations around the world, not so freedom of the press, not so much. But in the United States, this is a fundamental principle that the press should be free. Okay, so what about freedom of the press? The best example is, you guessed it, the New York Times case in 1971. All right, so the Vietnam War has been going on for quite some time. It started off popular, and then as time progressed, people turned against the Vietnam War, and the government knew the war effort was going bad, but they didn't tell the public. Okay, so here's what happened. In this case, the government tried to block publication of what's known as the Pentagon Papers, claiming it would harm the country. The Pentagon Papers was a report that basically said that the United States knew the war effort was bad, and we kept sending in troops anyway. So this is, bad press for the war effort and the government. So when the New York Times gets a hold of the Pentagon Papers, they're going to publish it, right? And the government's like, oh, not so fast. You can't do that. And the New York Times says, well, yes, we can. We have freedom of the press. So this will go to the Supreme Court. And, in this case, the New York Times will win. The phrase is prior restraint. When the government tries to prevent the publication of stuff, then that's known as prior restraint. So this case put a heavy burden on prior restraint. Prior restraints when the government prohibits the media from publishing certain materials. Okay, so the New York Times will win this case, and they will be allowed to print the Pentagon Papers, and this is a situation where freedom of the press will prevail. Now let's move to our Second Amendment. We're going to keep going down the list, and the right to bear arms. Now, this is a controversial issue, and I don't want to shy away from that because it's part of the curriculum. I'm supposed to, the College Board wants me to explain to you that the right to bear arms is an ongoing debate within our country, but nonetheless, it's in the Constitution, and you do have the right to own a gun. You have the right to bear arms. Okay. Has the Second Amendment been incorporated to the states? Yes, sure has. When did it happen? Well, it happened pretty recently. Please be aware of this date right here, 2010. So this is the most recent liberty listed in the Bill of Rights to be incorporated to the states. And this happened in the case of McDonald versus Chicago. Okay, what happened? In this case, a Chicago ordinance banning the possession of handguns, was challenged. So you got this guy, his name's Otis McDonald, and he's all discouraged because his home is being vandalized and it's been robbed. And he wants a handgun. He wants to possess a handgun for self-defense of his home. But in Chicago, handgun registration was not allowed in the city. I mean, it was just almost impossible to register a handgun in the city of Chicago, and it essentially takes away your right to bear arms. So, of course, Otis McDonald is going to, file suit because he wants to, own a handgun for self-defense. Now, what's going to happen? The Supreme Court ruled the ordinance to be, in fact, a violation of the right to bear arms, and it incorporated the Second Amendment to apply to the states through the Due Process Clause. Okay, so Second Amendment is incorporated. Now, what exactly did the court say in their majority opinion? The decision was based on the right to bear arms for self-defense in one's home. Okay, so make sure you remember that about the McDonald-Chicago case, is that the Supreme Court in their majority opinion talked about the importance for somebody to have, the right to own a gun or a handgun in this situation for self-defense in your home. So yes, the Second Amendment has been incorporated to apply to the states. Now, this is where we need to acknowledge that the Second Amendment right to bear arms is an ongoing debate. And often you'll see protests about, pro-guns versus, anti-gun. And I mean, it's just an ongoing thing in the United States because there are a lot of guns out there. So the question I pose to you guys, does the Second Amendment promote public safety, or does it interfere with public safety? Now, obviously, I'm not going to tell you guys my opinion because that's not what I do. Instead, I want you guys to formulate your own opinion, right? What does the Second Amendment do? Does it promote public safety? Because if you have a handgun to protect your home, you're going to feel safe from an intruder. But guns are violent tools, right? They lead to more violence, right? Interfere with public safety? Okay, you guys decide which way you want to go on this. But that is the debate. Does the Second Amendment promote public safety, or does it interfere with public safety? Now let's look at some data to kind of support the idea that there is a debate between the Second Amendment and guns in the United States. This graph is talking about the relationship between views on civil liberties and gun ownership. Percent who agree the specific right liberty is essential to their own sense of freedom. Okay, so gun owners, right? Non-gun owners were asked about these different liberties over here on the left side, right? Like freedom of speech. And they're asked if it is essential to their sense of freedom. Well, with freedom of speech, they're the same. Right to vote, they're the same. Right to privacy, pretty much the same, right? But when you get down here to right to own a gun, you'll see that gun owners feel at 74% that it's essential to their sense of freedom. Non-gun owners are at 35%, whereas they're basically the same across the board everywhere else. Okay, so the right to own guns is debated within the United States. This poll clearly shows there's an ongoing debate over whether gun control laws promote or interfere with individual rights. Now we'll move on to the Fourth Amendment. And when I say Fourth Amendment, you should automatically think due process. All right, Fourth Amendment says the right to be secure against unreasonable searches and seizures shall not be violated, and no warrants shall issue but upon probable cause. Okay, so Fourth Amendment, no unreasonable searches, right? And your stuff can't be seized. Also, no warrants shall be issued unless there's probable cause. All right, in other words, the government cannot seize or search or seize your stuff unless they have a warrant. Okay, so they got to have a warrant. Now, how does law enforcement get a warrant? Do they just, fill out a form and get it? Well, kind of, but you need probable cause. Okay, you can't just go search somebody's house because you don't like that person, right? There has to be a reason, right? So what is probable cause? It's a reasonable suspicion of a crime. Judges are the ones that issue warrants. So the judge has to determine whether or not your evidence is, is enough for probable cause or a reasonable suspicion of a crime. Police can't just do what they want. This is about protecting your rights, your liberties, right? You can't just have your stuff looked through. So can't go through your stuff unless you get a warrant. To get a warrant, you need probable cause. What is probable cause? Reasonable suspicion of a crime. This leads to what's known as the exclusionary rule. This is an interesting one, you guys. Obviously, we want to be safe, but we don't want our, privacy violated. And this is where the exclusionary rule comes into play. What happens if the police search your stuff without a warrant? Well, regardless of what they find, it cannot be used in a trial. What? Why? Because the evidence was obtained illegally without a warrant. So it doesn't matter if the police find, drugs or anything that's illegal. It doesn't matter what they find. If they obtained that evidence without a warrant, that can't be used at the trial. But what if the police goes in and there's all these drugs and this person's clearly guilty, but they went in without the warrant? Well, they're not going to let the criminal go free, right? Hold on, wait a minute. If they obtained the evidence without the warrant, they illegally obtained it, and therefore that evidence can't be used at the trial. Now, doesn't that weaken the power of the police? Well, sure it does, of course, but it also protects your civil liberties. So yes, the police having to jump through hoops and go through all the red tape in order to search and to go through these things, yes, it's hard for the police, and it does take some teeth away from law enforcement. But in our country, civil liberties are very important, and they're right there in the Bill of Rights, the supreme law of the land. So yes, the exclusionary rule does weaken the power of the police, or at least some argue it does. However, protecting civil liberties is critical. Now, I get this question a lot, and yes, it's on the AP curriculum. Does this include your cell phone? Yep, it does. In other words, police cannot obtain information on your phone unless they get a warrant and they need probable cause. Now let's move to our Fifth Amendment. Okay, now the Fifth Amendment isn't as big as the First Amendment, but it does have a lot in it. Okay, here we go. No person shall be subject to more than one punishment or trial for the same offense, nor shall be compelled to be a witness against himself, nor be deprived of life, liberty, or property without due process of law, nor be obliged to relinquish his property where it may be necessary for public use without just compensation, except in time of war or public danger. Whoa, what did I just say? Okay, let's break it down. Let's start with this one. Trial for the same offense. This means double jeopardy. Or in other words, Eagles, you cannot be tried twice for the same crime. Okay, so if you're arrested, you have your trial, you're found not guilty. Hooray, you're free, right? But then later, some evidence, the lost video was found, right? Of your crime, whatever you did. You robbed the 7-Eleven and somebody got it on their phone, but they don't produce the video till later and they see it on YouTube, right? Well, clearly you're guilty. There's the video. But wait, you've already had your trial, right? So can you be put back on trial? No, because of double jeopardy in the Fifth Amendment. You cannot be tried twice for the same crime. All right, witness against himself. That is known as pleading the Fifth, or you are choosing to refrain from testifying against yourself. Remember, Eagles, in the United States, it's innocent until proven guilty. not the other way around. So you don't have to prove your innocence. You're already innocent. Somebody else has to prove you're guilty. So if you feel like they don't have it they don't have the evidence, you can just plead the fifth, stay quiet, and say, hey, you can't convict me because you got to prove I'm guilty. So you can choose to stay quiet or plead the fifth. All right, eminent domain, relinquish their property. Okay, this is eminent domain. Can the government take your private property? Yes, they can. They'll do this to build a road. If the freeway needs to come over the top of your house, then sayonara house, it's over, right? If a school needs to be expanded or built on your property, the government can take it. It's called eminent domain. However, they do have to pay you. Now, pleading the fifth, in the Fifth Amendment, let's go into a little bit more detail. I did this at the start of the presentation. It's known as the Miranda rights, right? You can see it right there in the corner. You have the right to remain silent. Anything you say can be. All right. The police are required to read you your rights right off the bat. And if they fail to do that, and you say something like confess to the crime, again, it's like the exclusionary rule. It can't be used in court, right? This is known as the Miranda rights. If you look down here at this political cartoon, you got Lady Liberty standing over the top of this dude who's being intimidated, by law enforcement there, right? Okay, the Fifth Amendment right to refrain from testifying against yourself gives rise to the Miranda rights. And this came from a Supreme Court case, right? That's why it's called the Miranda rights. Now, this isn't one of your 15 cases, but it's still a case you should be familiar with, right? So really quick, you got this person, Ernesto Miranda, confessed to a crime after hours of intense interrogation. Okay, so person was the cops were just all over it. They're being intense. They're intimidating. And after a certain amount of time, Ernesto cracked and confessed. But the judge is like, whoa, whoa, whoa! You are violating the Fifth Amendment. They didn't know they had the right to remain silent. So this conviction was overturned, and from forward, moving on, the Miranda rights have to be read, right? Police must inform individuals of their rights. That's your Fifth Amendment. Now, Sixth Amendment. We already talked about this as our example to selective incorporation. I love this quote by Lincoln. Lincoln's so good, man. He who represents himself has a fool for a client. Waka, waka, waka. You go, Abraham. All right. Sixth Amendment. In all criminal prosecutions, the accused shall enjoy the right to a speedy and public trial by an impartial jury, to be informed of the nature of the accusation, and to have the assistance of counsel for his defense, right? Okay, Sixth Amendment, speedy and public trial. You are probably all familiar with this. Impartial jury, right? You have the right to a jury trial, and of course, the right to counsel for your defense. And Gideon versus Wainwright is where the right to counsel, the Sixth Amendment, is incorporated through the 14th Amendment's due process clause to apply to the states. Now let's move to the right to privacy. This is an interesting one. Eagles, the word privacy does not appear in the Constitution. What? Yeah, okay, so however, the right to privacy is implied throughout the Bill of Rights. This should not surprise us too much because we know about implied powers, right? The necessary and proper clause, executive orders that the laws be faithfully executed, right? So the right to privacy is one of those implied situations. But yes, the right to privacy is implied throughout the Bill of Rights, and therefore it is accepted at the same level as the other liberties in the Bill of Rights as a true liberty, the right to privacy. First Amendment, privacy of beliefs. This is where the right to privacy is implied. It's implied in the First Amendment through your privacy of beliefs. The Third Amendment, privacy of the home. The Third Amendment is the no force quartering of soldiers in your home, right? So the right to privacy is implied in the First, the Third, and the Fourth. Privacy of person and possessions. The Fourth Amendment, secure their persons, house, papers, and effects against unreasonable searches and seizures. So the right to privacy is implied in the First, Third, and Fourth Amendment. Now, obviously I'm going to attach a Supreme Court case to this, and it has been a subject of controversy, as we've seen in the Roe versus Wade case. So when we talk right to privacy on your AP test, it's likely that they'll attach the Roe versus Wade case to it. Okay, so Jane Roe, that's a pseudonym, it's not her real name, wanted to have an abortion, and she lives in Texas. Texas said, no, you can't have an abortion, so she files a lawsuit, and she wins, right? Okay, now, this case isn't so much about Jane Roe, but rather setting the precedent for abortion, right? Okay, so the Supreme Court is going to rule on this decision, and this decision was based on the right to privacy implied within the Bill of Rights. Okay, so the decision, Roe Wade extended the right to privacy to a woman's decision to have an abortion. So yes, you can have an abortion, but at the same time, recognizing state interests in potential life and maternal health. Women have a right to an abortion in the first trimester of pregnancy. The states get involved after that. States can impose restrictions in the second and third trimesters. Again, this is a heated debate within the United States, probably one of the most heated debates in the United States, the abortion debate. Again, I'm not here to tell you what your opinion should be. I'm just here to tell you about Roe versus Wade and how it was ruled, and it was ruled with the right to privacy. Death penalty. This is an interesting one, right? Is the death penalty allowed in the United States? Yep, sure is. But what about the Eighth Amendment? The Eighth Amendment says excessive bail shall not be required, nor excessive fines imposed, nor cruel and unusual punishment. Okay? Now some will say, dude, what's more cruel than you're dead, right? The death penalty? Okay, so the Supreme Court takes the difficult cases, so obviously they're going to have to take this one, right? Nor cruel and unusual punishment, and the Supreme Court has ruled that the death penalty is not necessarily cruel and unusual punishment. The death penalty remains controversial. States will choose whether or not the death penalty is used. This is a reflection of federalism. Some states, yes, death penalty is allowed. Other states, no way. So in the federal system, federalism, right? Each state's going to determine whether or not death penalty is going to be allowed or used. And the Supreme Court has ruled that it's not necessarily cruel and unusual punishment, and then they've left it up to state discretion. Now we'll go to the public order versus civil liberties debate. And I've alluded to this throughout the whole presentation, but I want to highlight it now. And you'll notice my picture in the top right corner. Yes, this is a tug of war between public order and civil liberties. Okay, let's go through this. What's more important, being safe or having your liberties protected? I guess it depends, right? Well, depends on what, dude? Well, what's going on at the time? If we're at war, maybe being safe is more important than having my liberties protected. So the public orders versus civil liberties debate will constantly be going back and forth depending on the current events. If there's a crisis in the nation, then public order will prevail, as history has shown. When there's not a crisis, when it's peace and prosperity, civil liberties will prevail. Now, some people feel that civil liberties should always prevail regardless, and other people feel public order should prevail regardless. But it goes back and forth, okay? What if we're not at war? Well, maybe protecting civil liberties is more important, right? So it's a debate back and forth. The balance between public order and civil liberties is ongoing. Eagles, I want you to be able to tell me examples of public order versus civil liberties. So let's go through some. Public order and safety first. What are some examples of where public order and safety prevailed? Okay, Civil War and World War II. Habeas corpus was suspended. Abraham Lincoln, FDR, Franklin D. Roosevelt, they suspended habeas corpus, which is put in the Articles, not in the Bill of Rights. Habeas corpus, the right to be brought in front of a judge and told why you're arrested, that was suspended during the Civil War and World War II. They were worried about spies, right? And that was allowed because it was a time of war. So public order and safety prevailed in those situations. World War I, we already know, Charles Schenck was arrested for protesting the World War I draft. If we weren't at war, Schenck probably wouldn't have been arrested or convicted, but we were at war, so in this case, public order is going to be seen as more critical. September 11th, 2001. This is a current event. The country was attacked. It was horrible. Terrorists, took out the World Trade Center, the Pentagon. My goodness, it was awful. And as a result, Congress passed what's known as the Patriot Act. The Patriot Act was intended to stop terrorism. However, it was controversial because it was said to permit searches without probable cause. It really put teeth into the intelligence agency to be able to search, phones and emails and without, going through the proper probable cause channels like normal. This would normally not ever be allowed. Patriot Act wouldn't have been passed. But after being attacked by terrorists on that day, it's a pretty horrible day. People were like, yeah, public order and safety, more important than civil liberties. The other side, civil liberties, let's give some examples where civil liberties prevailed. During the anti-Vietnam War movement, the war was not popular, public opinion was against it, and as a result, the New York Times had momentum on their side when they went to the Supreme Court, and they were permitted to publish the Pentagon Papers. Current events and public opinion will have momentum, and even though the Supreme Court is independent, they do not want to lose credibility with the public. So they will rule on the side of public opinion. They are human after all, right? Okay, another example, the exclusionary rule, where you must obtain a warrant, and if you get evidence or snag some evidence without the warrant, that's admissible in trial, right? Exclusionary rule, civil liberties prevail. And then there's another law. I know we haven't talked about it in class much, but it's called the USA Freedom Act. This law limits collecting phone metadata. Okay, so real quick, just note on that. USA Freedom Act, arguably, ended the ability of federal intelligence agencies to store certain phone metadata. Instead, phone companies could hold on to that data, and then federal intelligence agencies can search the phone company records, with a warrant. So it's going to put limits on collecting phone metadata. That's the USA Freedom Act. All right, now, civil liberties, civil rights, those terms are used interchangeably, but Eagles, they are different. You need to be able to tell me the difference between civil rights and civil liberties. We just went through civil liberties. Let's go to civil rights. What does civil rights mean? When I say civil rights, I'm talking about groups, all groups, race, gender, religion, right? All groups deserve to be protected from discrimination, right? All groups deserve to be protected from discrimination. Now, when I talk about civil liberties, I'm talking about the individual rights in the Bill of Rights, right, that an individual person should be protected against. When I'm talking about civil rights, I'm talking about groups being protected from discrimination. How are civil rights protected? Through various pieces of legislation and amendments, specifically the Equal Protection Clause in the 14th Amendment. There it is again, you guys, 14th Amendment, very important. Like the First Amendment, it has two clauses in it, okay, and let's go through it. No state shall deprive any person of life, liberty, or property without due process of law. Okay, we just went through that with civil liberties, but now we're going to do the other side of it, the other clause in the 14th Amendment. Nor deny any person within its jurisdiction the equal protection of the laws. Okay, this is the Equal Protection Clause, and it's specific to civil rights. When I say civil rights, you should think Equal Protection Clause. When I say civil liberties, you should think due process. But when I say civil rights, equal protection. All groups, regardless, deserve to be equally protected by the law. Okay. Have all groups always been protected? Nope, not even close, and we know that. What are some examples? I can give you a lot of examples. We can talk about how women didn't get the right to vote till 1920, right? We can talk about slavery, but let's just stick with suffrage and segregation. These are the examples that are likely on the AP exam, right? Let's start with suffrage. What is an example of a group being denied the right to vote? Well, there's several we could give, obviously, but let's do the Reconstruction thing. Now, the 15th Amendment was passed in the wake of the Civil War, and it was passed giving male African Americans the right to vote. But in the South in particular, states were like, we're going to kind of ignore that amendment, and we're going to disenfranchise African Americans in another way. How did they do it? Well, they charged poll taxes. Really? Charge money to vote? Come on. Oh, pass a literacy test? Really? And then there's this thing called the Grandfather Clause, which was a law that said if you could vote before the Civil War, right, then you don't have to do the poll tax or the literacy test. Okay, so these were the ways to get around the 15th Amendment that the states used to disenfranchise African Americans and other potential voters. Let's go into segregation now. What is segregation? This is separation of the races. Schools, parks, buses, restaurants, drinking fountains, right? If you're one particular race, you go over here. If you're another particular race, you go over there. We're going to separate the races, right? Dude, there's no way segregation is allowed. That's not real, right? Hold on. Yes, it is. And it was part of American culture for way too long, and the Supreme Court backed it up in a Supreme Court case in 1896. Plessy Ferguson, not one of your 15 cases, but you still should know it. In this case, the Supreme Court ruled that segregation is allowed as long as the facilities are equal. Okay, this is known as the separate but equal doctrine. Yes, this is real. Segregation was constitutionally allowed for a time as long as the facilities are equal, right? Okay, will this last? No, it will not. Are you kidding me? How long did this last? Well, it lasted until Brown versus Board of Education in 1954. Should be familiar with this one too. African-American student Linda Brown, she wanted to attend an all-white public school. She couldn't because of segregation laws, so she filed a lawsuit. She won. She won. The Supreme Court ruled that the separate but equal doctrine was unconstitutional. Okay, and it violated what clause? You should already know this. It is the Equal Protection Clause, right? So in the Supreme Court case, Brown versus Board of Education, segregation is a violation of the Equal Protection Clause. After this case, the momentum, the spark was lit, and the civil rights movement took off. Speaking of the civil rights movement, that's our next topic, social movements. What are some examples of social movements that have brought about civil rights reform? Okay, we know about the African American civil rights movement. That's what most people associate civil rights with. But that's not it. There's also the women's rights movement, right? Women's liberation movement was huge. There's a picture, equality, the time is now. And of course, that is referring to the National Organization for Women, right? Very important organization fighting for women's rights. And then you have the LGBTQ movement. And you still have your pro-life movement, right? That's another example, the anti-abortion movement. So you have various social movements that brought about civil rights reform. Now, 9 foundational documents. This is a big one. It's the letter from Birmingham jail. This is one of my favorite pieces of American history. I love Dr. King's letter from Birmingham jail. It's a long, piece, and Dr. King admits that it's long. He's like, hey, I know this is long, but what else do I have to do while I sit here in prison, right? Okay, what is it about? The purpose is to argue that all people should be equal under the law, and there it is again, as embodied in the Equal Protection Clause, right? He's fighting about, the Equal Protection Clause of the 14th Amendment. So what happened? Well, during a march, an act of civil disobedience, right? This is Dr. King's strategy. It worked great. Civil disobedience. We could talk about the sit-in movements and the different protests. So this was an act of civil disobedience. During a march in Birmingham, Dr. King, he's arrested. Now, he was arrested unjustly. What's he doing, right? He's peacefully protesting. Wait a minute, is that against the Constitution? The right to peacefully assemble and petition the government, First Amendment? Okay, what's going on here, right? So while he's in jail, he composed his famous letter from Birmingham jail, and he argues against the idea of wait. Within his letter, King lays out 4 steps of nonviolent campaigns. 1, collection of the facts to determine injustices. 2, negotiation. 3, self-purification. 4, direct action. Okay, obviously I got to throw out a quote from the letter of Birmingham jail. This is a great quote. The answer lies in the fact that there are 2 types of laws, just and unjust. All segregation statutes are unjust because, right, thesis statement, because segregation distorts the soul and damages the personality. A law is unjust if it is inflicted on a minority that, as a result of being denied the right to vote, reasoning point, right? Way to go, Dr. King. As a result of being denied the right to vote, had no part in enacting or devising the law. You go, Dr. King. That's a great quote in the letter from Birmingham jail fighting for equal rights. Now, we're talking about social reform movements. Let's talk about the laws that have been passed because of these social reform movements. Brown versus Board of Education, we know. Civil Rights of 1964, you should know if you took American history. Voting Rights Act of 1965, also you should be familiar with. We've talked about these. Here's a new one. Title IX of the Education Amendments Act, and affirmative action. Okay, now the response to social reform movement, Civil Rights Act, this was passed to enforce the 14th Amendment more clearly. Discrimination in public accommodations was made illegal as a direct result. Voting Rights Act of 65 enforced the 15th Amendment more clearly. This was a major instrument for increasing the number of African Americans and other minority voters. Once the Voting Rights Act of 1965 was passed, look at the number of African American Southern state legislatures. It just climbs and climbs and climbs as a result of the Voting Rights Act of 1965. Now, let's bring up Title IX. Hopefully you've heard about this. This is a great piece of legislation. Now, the law is Title IX of the Education Amendments Act, so it's a part of the Education Amendment Act. What it says is that no person shall be excluded on the basis of gender from participating of any educational program receiving federal funding. What did this mostly do? It improved participation in athletics for women. You'll notice this graph right here. In 1971-72, girls participating, 7.4 in high school sports. That's like nothing, right? Well, after the Title IX of the Education Amendments Act was passed, look at women participation in high school athletics. It climbs and climbs and climbs. This piece of legislation was really big in promoting equality in athletics. Also, a response to social reform movements is affirmative action. We've already talked about this a little bit, but it is a result from reform movements. These are policies to improve opportunities for minorities, women, and disadvantaged, especially in relation to employment or education. So sometimes they'll take race or gender as a plus factor, not the only thing, but a plus factor when admitting students to college. Now, support for affirmative action programs is pretty high. You got most people who, they're okay with it, but when you get down here, even though it's not higher, it's still a majority of white men and white women support affirmative action. However, I do need to point out that this is an ongoing debate. between judges and within the country. Is affirmative action a good policy to have?